I'm Lorraine Williams. I'm a Senior Employment Law Consultant with Outset UK Limited. Today I'm going to talk to you about unfair dismissal for legal training TV. An employer who dismisses an employee without good reason or without following a fair procedure lays himself open to a potential claim for unfair dismissal. When such a claim is brought, the employer has to establish the reason for the dismissal. The Employment Tribunal will then consider whether the dismissal was fair in all the circumstances. If the dismissal is held to be unfair, the employer can be ordered to re-engage or reinstate the ex-employee or pay compensation. The areas that we will be looking at today are the time limits for bringing a claim for unfair dismissal and other qualifying conditions such as length of service and the requirement to be an employee. We will also look at certain dismissals which are automatically unfair and which do not require a specific length of service. We will also then look at the 6 potential fair reasons for dismissal, being capability or qualification, conduct of the employee, retirement, redundancy, some other substantial reason, and illegality. We will then move on to look at the general fairness requirements under Section 98(4) of the Employment Rights Act 1996. And finally, we will look at remedies that are available and how the calculation of compensatory awards are made. We will then round up the session with a summary of the process that should be followed in conducting a potentially fair dismissal to try and avoid the pitfalls which have been highlighted throughout the presentation. There will be 2 processes, one which applies to the majority of dismissals, be they for capability or conduct and some other substantial reason, and the different procedure that applies to retirement dismissals. To start with, we'll look at time limits in terms of who can bring a claim. Generally, a tribunal claim for unfair dismissal should be brought within 3 months of the effective date of termination of the employment. In certain circumstances, this can be extended to a period of 6 months, and this is normally where the statutory minimum dismissal procedures apply, where a grievance is required to be lodged prior to the claim being submitted to the tribunal. In this instance, the time limit is extended to 6 months. A claim will not be successfully submitted to the Employment Tribunal in various circumstances, including where the claimant has not raised a grievance under the statutory process where it is required to do so, where the claimant did not wait 28 days between raising that grievance if required and submitting the claim to the tribunal, or if the grievance was raised more than 1 month after the end of the normal 3-month time limit. In those circumstances, the claim will not be admitted by the tribunal. There are also other qualifying conditions to bring an unfair dismissal claim. The claimant must be an employee. Therefore, if they're self-employed or a subcontractor, they do not have the protection of unfair dismissal rights. The employee must also have 1 year's continuous service. There are some exceptions to that which I will deal with later on.